Hey everyone, we're just going to give people about a minute here to get logged in and then we'll get started.
All right, Scout, why don't we go ahead and let's get rolling.
All right. Well, hello everyone. Good afternoon, and thank you for joining our webinar today. It's been I think, about 3 months since we last met to talk about understanding and implementing the Earned Sick Time Act. And so we thought it would be a good time to revisit the Earned Sick Time Act and talk about just some of the questions, especially that have come up over the last few months, since some of you with more than 10 employees have implemented the Earned Sick Time Act back in February. But then it would also be helpful for those of you with 10 or fewer employees as you begin to prepare for policy implementation this October. It's a good time to revisit things to make sure that you have the information that you need to be successful with your implementation of ESTA. So with that, I'll just also introduce myself. My name is Scout Sparks, and I lead the Human Resources Department here at SBAM. I'm partnering here with Brian Calley today to talk about the Earned Sick Time Act.
Very good, thanks, Scout. The first point is just to refresh the timeline itself. So the timeline was established based on employee count, and we're going to talk about how to count under this act. So it's not as easy as how many digits on your fingers. There's certain employees, types of workers count toward your head count, some don't. But the point, so we'll get to that in a few minutes, but if you do have 11 or more employees, you're already supposed to have implemented this. We do have some concerns out there that not everybody has heard about this. We've been talking a lot about it, but people that own businesses, your head's down, you're working the business and don't necessarily know when the government changes the rules on you. It has been enough time. I am concerned that if you do have more than 10 employees, 11 or more employees, that there would, if you were caught not complying or an employee made a complaint, there's every day a little less sympathy for I didn't hear about it. And so it's really important. I want you to consider it an urgent issue to get this in place if you have 10 or more employees. If you have fewer than 10 employees, or 10 or fewer, so 1 to 10 employees, then your compliance deadline is October 1st. So there's still plenty of time and lots of decisions to make. You have some latitude in how you implement this. We're going to get into all of that. One kind of asterisk on this timeline is that if you are a business who first hired an employee in the last 3 years, you have from 3 years of your first employee hire to comply with this. So there is a delay, if you will, in the requirement to comply with this law based on when you first hired an employee. Keep in mind that is not the same as when you started the business, when you filed your articles of incorporation or something of that nature. That's not what we're talking about here. The date of your first employee hire. You might ask, does the owner count? Well, if the owner is drawing W-2 wages, then yes, the owner counts. But if the owner is not drawing W-2 wages from the business, if you're just taking distributions from an LLC or something of that nature, no, the owner does not count as the first hire of the business. So just to give a little, if you happen to fall in this category, think, wow, I hired my first employee 2 years ago. Well, you still have one more year before you have to comply with this law. If you hired your first employee more than 3 years ago, then depending on your head count, you either had to comply in February or you have until February or October 1st. There'll be time for questions at the end of this webinar, so we'll hang out as long as we can, just kind of walking through and working through your questions when we get to the end. Okay, Scout.
All right, so let's first start with just revisiting the definition of the Earned Sick Time Act. It requires businesses to provide employees with the right to accrue and use sick time for purposes really extending beyond just the employee themselves. And that's what's really different here, apart from standard paid time off policies where the employee can use maybe some sick time if they're not feeling well. The Earned Sick Time Act applies to not only the employee, but also family members and other reasons as well. So for purposes related to personal or family health needs, but also domestic violence and sexual assault. Also, a child's health or disability is covered under the Act, as well as public health emergencies. So something to keep in mind before we head into this step-by-step approach that we've outlined. Just kind of have that in the back of your mind that this applies to the employee and their family members. So next I'll start here with step 1A. And if you've joined our webinars in the past, you will notice some differences here. We've changed some of the contents in this webinar to kind of shed some light on some of the questions that have come up since many of you have implemented the Earned Sick Time Act since February. So I'll start with which businesses need to comply. First of all, it's all Michigan employers that have one or more employees. So it would include any person, firm, business, educational institutions, schools, corporations, LLCs, and government entities, all of which are required to comply with the Earned Sick Time Act. What we really wanted to emphasize here is that it includes nonprofit agencies. We've fielded some questions, asking if nonprofit agencies have to comply. There was some confusion around that topic just after the Earned Sick Time Act was amended at the end of February. But we have confirmed the way that the law is written, nonprofit agencies are required to comply with the Earned Sick Time Act. However, there's a small category of employees who are exempt from the Act. So that would be employees of the U.S. government, unpaid trainees or unpaid interns. They would not be eligible for earned sick time. Similarly, individuals who are employed in accordance with the Youth Employee Standards Act, so essentially minors that you've employed are not eligible for earned sick time benefits. And then also in general, or generally speaking, publicly elected officials, members of publicly appointed boards and commissions are not considered employees for purposes of ESTA. But there is one more exemption here that we wanted to talk a little bit more on in step 1B. So I'll pass that over to you, Brian.
This one was an amendment. It comes from an amendment that came to the or that was implemented as part of the passage on February 21st of this year, and it created a lot of questions. Like, I wonder if any of my employees would fit under this exemption. In other words, an employee that is not entitled to the benefit of earned sick time, and this one exemption was defined extremely narrowly. So if you're wondering, are any of my employees exempt from the Earned Sick Time Act? The answer is probably no. But the way that they've laid this out is that there are two conditions for somebody getting an exemption. If the person can schedule their own working hours, that does not mean pick their shifts. If you say, oh, here's some shifts, pick any shift you want, that does not count for this exemption. This only applies for the two things. If the person has work from you, but they can do it anytime they want, in the middle of the night, in the middle of the day, they, literally anytime they want to do the work, they can do the work. That's one of the things. So not picking shifts, but picking the hours that they work and being able to do so at any point in the 24-hour cycle. And then also that there's no adverse action from them declining the work. Those are the two main conditions. And they gave some examples that show just how narrow this is. So generally speaking, if you have an employee that fits this definition, they're probably more likely an independent contractor than an employee, or they would fit the terms, most of the terms of independent contractors. So for the vast majority of circumstances, every employee in your business is going to be entitled to this benefit. And there's a couple of scenarios we're going to walk through in a little while that where you have employees that are technically entitled to the benefit, but they may never qualify for it. We'll get to that in just a few minutes. But ultimately, this exemption that had piqued a lot of interest. I want you to think of it very narrowly, and it's going to be very difficult to qualify for it.
All right, moving into step 2, which would be to determine your head count. And so this is where it's really important when it comes to determining the size of your business, if you have 10 or fewer employees or 11 or more. When you're doing this exercise, you'll want to include all full-time employees, part-time employees, seasonal and temporary employees in this calculation, regardless of their work location. So this would also encompass if you have employees working outside of Michigan, they should also be included in that calculation. An employer is considered a small business if they employ 10 or fewer employees. And then if a small business hires more employees and that headcount increases to, let's say, 11, it's still classified as a small business as 10 or fewer under the Earned Sick Time Act until it reaches a threshold of operating with 11 or more for at least 20 weeks. So if you cross that threshold and you have 11 employees for less than 20 weeks, you would still maintain that status as a small business with 10 or fewer employees. So we've already talked about that the calculation should include employees who work anywhere in the US, only for purposes of calculating the headcount. But then also if if you have a temporary employee and they are sourced and employed by a third-party staffing agency, then the staffing agency is required to provide the paid sick leave benefit. But for purposes of the head count, you should still include that temporary employee as part of the head count if they've worked at least 20 weeks.
I think this is a pretty important, it's a pretty important distinction that it's one of the things I really don't like about this law is that they have these different standards for counting to 10 includes all your employees. So are you considered small or not? You have to count you have to count the not independent contractors, but you have to count temporary workers. You have to count workers that are in other places, other states. This is to determine if you're big or not. So in other words, an example would be Tesla. They have thousands of employees elsewhere, but what if they had 5 employees in Michigan? Doesn't matter that they only have 5 in Michigan. For the purpose of this act, they're considered big because the whole empire, like all of the employees, are more than 10. But that's different than who you have to provide the benefit to. You don't have to provide the benefit to those who are employed outside of Michigan. You don't have to provide the benefit to those who are employed by a third-party staffing agency, but they go toward your headcount to determine whether you're a small business or a larger business, in which case, according to the state government, if you have 11 or more employees, congratulations, you're a large business now. It's kind of an absurdly narrow definition of small business, but this head count is just to determine, are you in the small business category or the bigger business category? It's different than which of your employees get the benefit. and that headcount get the benefit. It's only those that are physically located in Michigan that you provide the benefit to. All of your employees, even those in other states, count toward this headcount calculation.
All right, so we'll get into step 3, which is leave structure. So you have a few different options here when it comes to determining the type of policy that you choose to implement, if you haven't done so already. And we'll talk about how to use these different methods here in the coming slides. But to start, you have the option to accrue the benefit at 1 hour for every 30 hours worked. And so the minimum amount of hours for small employers with 10 or fewer employees would be up to 40 hours, and then 72 hours for employers with 11 or more. So that accrual that would change depending on the size of your business. That's why it's important to first determine the head count, and then that will help you determine what that accrual looks like for your business. Alternatively, you can provide a front-loaded amount available for immediate use. So that would be, if you're a small employer, it would be 40 hours front-loaded at the start of the benefit year, or 72 hours for employers with 11 or more employees. So you can accrue or front load those hours. You can also choose to combine either accrued or front-loaded leave with another form of paid time off benefits that you currently offer. So you can kind of combine those two together into one policy, and we'll talk more about that in a second. But then also, employers can use both methods for different employee classifications. So what we mean by that is maybe you have all of your full-time employees, you could choose to front load the earned sick time hours for that group, for that classification. But then for your part-time employees, you could opt to have them accrue paid sick leave benefits. Whatever you do, you just want to make sure that you're offering the same for similarly classified, or similarly situated employees. You would not want to offer accrued benefits to some part-time employees, but then front-loaded to the other part-time employees. You'd want to be consistent in how those employees are classified.
So there are some pros and cons depending on which you pick, whether you accrue or you front load. Do you give all the time right up front? Do you make people earn it by the number of hours that they work and just have it kind of incrementally grow? So a few things, just want to cover some of those pros and cons. First is on the accrual-based method, you must track hours worked for non-exempt employees. And non-exempt employees, we're talking about under the Fair Labor Standards Act, who qualifies for overtime and who doesn't. So for workers who get overtime, they're eligible to and entitled to overtime, you must track the actual hours worked and make sure that you're awarding the time and keep record for 3 years of the time that they earned, so you can show that you awarded the amount you were supposed to based on the amount that they worked. For like salaried employees that would generally be exempt from overtime, then in those cases, you can just assume a regular or standard work week. If it's say 40 hours, if that's the regular work week for somebody, you don't have to actually track the hours worked for accrued, you can assume. But for those entitled to overtime, you must track and retain those records. Accrual-based, bullet number 2, accrual-based method allows employers to include a waiting period before somebody can use the benefit. So if you have a new employee, they can use the benefit, or I mean, they start accruing the benefit on their very first day of work, but you don't have to let them use the benefit until after 120 days. That's for accrual only. For accrual only, you can make them wait 120 days before they can use the benefit. If you're front loading, you can't put a waiting period in there. Okay, under the front loading method, you're required to track hours for part-time employees. So even if you give all the amount up front, well, if they're full-time, you're giving them the full amount up front that the law requires. If they're part-time, you can prorate the amount. So if a full-time worker, they're entitled to 72 hours per year, well, you can prorate down depending on how many regular hours you expect them to work in the year. But there are some catches to it. So you're front loading it and you're prorating the amount that you give them based on the amount that you expect them to work, but you still have to track their hours and then do a true up at the end of the year to determine, hey, did they work the amount of hours that I thought they were supposed to? Did they end up working more and therefore I need to award more hours after you become aware that you didn't give them enough up front? For part-time workers, unfortunately, you still have to track their hours and determine, is the amount that you front loaded the right amount at the end of the year? And then the other thing you have to do under that is you have to tell the employee, the part-time employee, here's how much we're front loading, and it's based on this many hours I expect you to work. You have to let them in on your calculation. That's actually in the law that you have to do that. So if you have part-time workers, a lot of employers are saying, well, if I got to track the hours anyway, I might as well go with accrual method. It's unfortunate that they make you jump through all those hoops because it's pushing more employers to an accrual-based method, which employees generally do not prefer. Under the front loading method, so if you give all the hours up front, you're not required to accrue or track time. Okay, so you don't have to, it's in that way, it's simpler, but you may not require an employee to wait 120 days before using it. So that's the downside. So front loaded, it's simpler except for part-time employees. But you cannot make an employee wait to use the benefit. Accrual is more complex. You got to track all the time and keep the records, but you can make somebody wait 120 days before they use it. So those are some pros and cons that we see in it. But of course, it's up to you. The law does have the flexibility, and the state's FAQs, the regulator FAQs, confirm your ability to pick between these methods. And you can mix and match as long as similarly situated employees are treated the same. So you could say, for example, I'm going to front load for full-time workers, salaried workers, and I'm gonna do accrual base for hourly workers. You could do that. You could say I'm gonna do accrual for part-time workers, and I'm gonna do front-loaded for full-time workers. Again, similarly situated employees need to be treated the same, but it doesn't mean you can't create cohorts within your business to establish the benefits according to within the parameters, the options that the law gives you.
All right, so we've broken down step 5 into 2 different sections here. Starting with the first decision point, which relates to your carryover decision at the end of your benefit year. So whether that's a fiscal year or a calendar year, you would determine what that is. But depending on the method, so if it's accrued or front-loaded, the carryover will look different depending on which method you choose. So unused accrued ESTA or earned sick time leave must be carried over into the new year, or you can pay it out at the end of the year. Up to either 40 or 72 hours, the carryover is not unlimited. So that's one decision to make. If you are going the accrual route, determine in your policy, if you have not done so already, if you are just going to have those balances be carried over into the new year, or if you're going to opt to pay out those hours at the end of the year. And then also with front-loaded earned sick time, if there's any unused front-loaded time at the end of your benefit year, you're not required to carry anything over into the next year. Unless, I mean, there's nothing that says that you can't pay it out. So if that's something that you'd like to do, you can certainly do that. But there are no requirements to carry over those hours under the front-loading method. So a couple of things to think about when it comes to choosing which policy that you'd like to go with.
The second step, second part of step 5 is your policy around separation of employment. This has to do with carryover as well, or whether or not you need to pay out, I should say. So the first is at the separation of employment, you are not required under this law to pay unused time to the employee who is separating from you. So it's just a policy decision that you make. Now, the law does say, not the Earned Sick Time Act, but a different law in Michigan from 1978 says that if you say you're going to pay it out in your handbook, that you must live up to what your handbook says. But you're not required to put it in your handbook that way. So just I would encourage you to just check your handbook and what it says on unused paid time off. Does it say that you should pay it out or not? You get to decide whether or not you do. Now, what if somebody leaves your employee but then comes back? That is actually addressed in the law as well. And the threshold is 2 months. So if somebody is hired and returns back within 2 months, then you maintain it's as if they never left. They pick up wherever they were. They get to if they had unused Earned Sick Time Act time in their leave bank when they left, they start right back off with it. If they're gone for more than 2 months, if they're gone for more than 2 months, then it's not it's like you just treat them like they're brand new. The old sick time just went away. If they had unused sick time, it just is cleaned off the books. They come back greater than 2 months later, then they are not entitled to pick up where they left off. You treat them as a brand new employee with a leave bank with 0 in it if they're accruing or just front loading accrued for the remainder of that year, or calculated or prorated for the remainder of the year. The one other item, this third bullet point, seasonal workers. Seasonal workers are not exempt from this law. However, in other words, you have to provide this benefit to seasonal employees. They are not an exemption under the law. However, because of this, because you can put for accrued benefits, 120-day waiting period before a person can use it. If you have seasonal workers that are with you for less than 120 days, then you can classify them as under the accrued benefit, and they will accrue the benefit, but if they are with you for less than 120 days, they'll leave before they could ever use it. It's almost like a de facto seasonal workers less than 120 days. It's almost like a de facto exemption. They are not exempt under this law, but because they're not there for 120 days, they never get to a point where they can use the benefit. So wanted to address or call out seasonal workers because there's been a little bit of confusion, people saying, wait, are they exempt or not? No, they're not exempt, but if they're with you for less than 120 days, then they'll never get to a point where they're eligible to use the benefit as long as you're choosing the accrual method. If you're choosing the front-loaded method, again, remember, you cannot put a waiting period on it. A seasonal worker would be entitled to the benefit on the first day of employment.
All right, step 6, we get into policy decision. So a few different policy options can include combined and front-loaded PTO. So you'd be combining paid sick leave with perhaps another paid time off benefit that you may currently offer. So you'd be pairing those two together to create one policy. A front-loaded policy solely to comply with, earned sick time purposes only. And those hours would be front-loaded at the start of the year. But then you could also do an accrual-based policy only for those earned sick time purposes. And then you can do a scenario where it's combined and accrued paid time off. And so we'll talk more about what that could look like. But it's also worth noting as well, if you're not familiar, SBAM has released an ESTA toolkit. complete with all of these templates ready to be used. Depending on the needs of your business, you can choose which policy template works well for you, and they can be customized to be plugged directly into your handbook. So we'll get into a little bit about more what that could look like for you here in the coming slides.
All right, we'll jump into step 7. Just a reminder, we'll do questions at the end, so please do put them in the chat, and we'll get to we'll run through them there at the end. So absence and notification, job abandonment decision. So this law, as it passed, does allow notification requirements. It's different than documentation requirements. Okay, so there's two different things here. When do you have to be notified by the employee that they're going to use it? And then there's a separate issue on whether or not you can require documentation for them to prove their reason for being gone. A lot of times people mix these two issues up. They're different issues under the law, different conditions for both. Okay, so you can require a notification procedure for both foreseeable and unforeseeable absences or somebody being tardy or late to employment. So the standard that's in place that's in the law says that you can require the employee to notify of their absence as soon as they are aware of the need to use earned sick time. So that means that no call, no show is you don't have to live with no call, no shows. There was some concern before when this proposal was working through that there's be all these issues where an employee could not show up and you couldn't do anything about it because they let you know after the fact. That is not the case. As soon as they are aware of the need to use earned sick time, you can require that they notify you of that. And surely if they're not there for the beginning of their shift, they're aware that they're not there for the beginning of their shift. And so if you were to say, if you could establish, for example, a policy that says you must notify the employer or your supervisor in a manner satisfactory to you, that before the start of a shift, you must notify it before the start of the shift, because surely they are aware by the time the shift starts that they're not going to be there. Okay, so you may still have notification requirements for the use of earned sick time. There is, we do have in our template the way to make sure that you've kind of dotted all your I's and crossed all your T's with respect to a job abandonment policy. So most employers have in their handbook something that's to the effect of, if a person is gone for 3 days, 3 consecutive days, without notifying their employer, it's not that you fired them, you consider that they quit. And that matters with unemployment claims later on. So job abandonment policies would suggest that if somebody's gone for 3 consecutive days, that you consider that they have quit, not that you have fired them. And so their employment ends. You can still have job abandonment policies under this law. There is one narrow exception that you should probably account for in your handbook, and that is that if a person is literally incapacitated. So because you can only enforce and terminate based on things that aren't protected in the act, if a person was, for example, in a car accident and they were literally unconscious, and so they didn't notify you of their absence, that is an absence that is protected under this law, and so you can't take disciplinary action against them because of that. It's a very narrow exception where a person is literally incapacitated to a point where it's not even possible for them to communicate with you. That's otherwise, job abandonment policies are fine. Notification requirements are fine under this law. You can still make all of those all of those things happen. You must notify, or you must put in writing to your employees how they are expected to notify you. If you're going to require notification, you have to tell them how to notify you. But again, Just want to underline it, make clear, because there's been confusion on this in the past. You may require notification requirements. You may enforce the job abandonment policies, the general 3-day no call, no show job abandonment policy.
And I also wanted to mention too, in the toolkit that's available, we've included a template, a policy template, for expectations of when to notify you if an employee is going to be absent or tardy and late to the start of their shift. That's something that you can use that also complies with this law.
So number 8, step 8 is once you make all these decisions, so you chose how you're going to handle if you're going to do accrued or front loaded, if you count as a small business or a not small business under this law, you went through and picked or decided what your notification requirements are going to be, and now you're ready to update your handbook. If you're operating without a handbook, let this be the thing that inspires you to get that corrected. Employee handbooks are really important. These are your employment policies, and there's a risk of operating without it, because what is expected and what you're required to do and being able to demonstrate later on, if there's ever a complaint, if there's ever somebody who challenges, said, oh, I didn't get it the same amount of time I thought, or I thought I was hired under these circumstances, but really they didn't live up to their obligations under what was represented to me when I was first hired. There's all of that can be mitigated by having a handbook that the employee acknowledges that they have read, that indicate here are the rules of employment here. So I want to encourage you to make sure that you do dutifully update your handbook when changes are made in the law, such as the Earned Sick Time Act. But if you don't have a handbook, please do rectify that. Establish a handbook. Our templates that we have for the Earned Sick Time Act could maybe be the seeds of that, to at least establish a paid time off or Earned Sick Time Act leave policy, and ensure that you've thought through and established exactly how all these things will be handled, and protect yourself, especially if you have a dispute later on when somebody says, hey, the employer didn't do what they're supposed to do. You can say, I acted according to my handbook, and here's where the employee acknowledged that that they understood the terms of employment as outlined in the handbook.
All right, so we've talked about the requirements of the Earned Sick Time Act, and then also your different options as it relates to implementing the policy to comply. And then we've updated the handbook. And so now we get into kind of the maintenance after the Earned Sick Time Act policy takes effect in your company. So what that would look like for tracking and record keeping will depend on the method that you choose. So with accrual based, you would still that's a little bit more of an administrative burden, in that you have to track hours worked, especially for your non-exempt employees who are hourly, and sometimes maybe their hours may vary depending on overtime worked per week. So it's important to track hours worked, and then also track accruals. Whether that's, they accrue their paid sick leave with every pay period, you'll want to make sure that is tracked to make sure that they're getting the appropriate accrual every year. And then also tracking their paid sick leave hours used as well. So when tracking that usage will be important with the accrual-based method. Under the front-loading method, accruals and time tracking, that's not required. So that's really kind of a benefit of front-loading, is that you front-load the hours at the start of the year, and really little to no tracking, unless of course you're front-loading to part-time employees. Then of course you'll need to provide that letter of estimation of benefits at the start of the year, and then kind of do a true up at the end of the year, audit that, and make sure that they did receive the appropriate amount of hours. And if they didn't, you'll want to make sure that you provide the difference if that's the case. And then also with the front loading method is you'll still want to track the hours that they've used for paid sick leave. So track that either way with the accrual based method or front loading, still track their paid sick leave usage regardless. You'll want to incorporate into your time off request process. So most payroll vendors are capable of doing this if you have kind of linked your time off request process or workflow into your payroll provider system. You should have the ability to add a way for the employee to declare the type of leave that they're using. So if they're requesting to use earned sick time hours, they should be able to indicate that in the request process. But if you're not there yet, if you're not at, if that's not automated, then you could just make it maybe an option on a paper form. Whatever you need to do to make sure that that's clear that they're able to declare if it's ESTA leave or if it's maybe just general PTO. And then also determine a system for how you'll record and store accrual information and usage for at least 3 years. So you'll want to keep a record of everything for all of your employees for a minimum of 3 years is required under the law.
All right, step 10, final step here, communication. So you are required to communicate this policy, the Earned Sick Time Act, the rights that employees have to them. The date for that was actually, it's already passed, March 23rd. There was not, it's kind of, I don't know if you'd consider it maybe an oversight in the law. It didn't make a distinction between 1 to 10 employees who don't even have to comply with this law until October 1st, and those 11 or greater employees that should already be compliant with it. The notification of rights to employees was March 23rd for everybody. So if you haven't, I wouldn't worry too much about this if you haven't done it yet. I don't think that there's notification police out there that I haven't heard about any sort of kind of enforcement action around this, but I would encourage you to do so it's as soon as possible to share with employees, whether it's whether you've already implemented this, but maybe you didn't send them a notice yet, or if it's coming up in October and you haven't told them about it. The state has a poster, an employment poster. There's 2 things you're required to do. You're required to post that at the place of employment. So wherever you have your other employment posters, this would go there as well. The state has one. I think we're going to provide you the link on this, and you can just print out the state's poster, and it doesn't have to be in color, it doesn't have to be in cardstock, just literally printing it out. As long as you've got ink in your printer and it's legible, you can just post that and you're good. You can also give that exact same poster. That can be what you give to your employees, saying, here's a new law that passed, we're required to notify you of this, and we're incorporating this into our policies. So using the state, I think it's a good safe place as opposed to trying to do your own notification. Use the state's poster. That way you covered everything in there and you covered it to the state's satisfaction because you used their own words to do so. Now, one other item I wanted to mention in this area in terms of notification, you're required to post this at the place of employment, but what if you have remote workers and they don't come into the office, or they don't come into the office very much? That in that case, the law doesn't address this, the state's FAQs don't address this, but it's probably a good idea to create some sort of a share folder or share file on your system, your computer system that employees have access to, and share that file with everybody in that works for the company. And then when you do that, while they're not going to be in the break room and see the folders because they don't work there, if they're on your system, they're working remotely and they have access to your system, then they could look up the folder there if they ever wanted to, in the notice that you posted there. So these are the minimum requirements. Also, by the way, if you hire a new employee, at the time when employment is extended and accepted, so not on the first day of employment, but when you extend and somebody accepts employment with you, at that point, you're supposed to notify them of your rights. Probably a good practice if you extend an offer to somebody at that point, go ahead and just add this to the paperwork that you give them when you extend the offer. And that way you'll know that by the time that they accept it, you've already met the requirements of notification. But as with many things, the bare minimum that is required under the law is probably not enough when you have a change this big. So Scout, maybe some best practices and things you'd suggest with employees as you walk through these changes.
Yeah, and I think especially for those of you who are ramping up to roll out the policy and effective October 1st, some things that you could do once you've updated the handbook to include your Earned Sick Time Act policy, we would recommend hosting maybe a meeting, gathering everybody together to review in detail what is now available to them, apart from just providing a copy of the notice. I think a lot of us can agree that this is pretty complex and it's confusing and it's uncharted territory. So schedule a meeting, review the new policy, the new benefit that your employees are entitled to, but also kind of like systematically how it works. What's the process for requesting the time off? How would you like them to notify you of an absence? Is that a phone call? Is that a text message? Really make it a priority to outline the policy, what's changing, and what are the new expectations. Because there's expectations for the employer, but then also the employees um, should have the, similar expectations as well in terms of what their responsibilities are. So host a meeting, but then also I recommend, a basic handbook acknowledgement that your employees can sign to acknowledge that they understand the changes to the handbook. And then saving that to their personnel files is a really, really good best practice. In the event of a dispute, if someone claims that they have no idea that they were never told that they had this benefit or they didn't understand, you could, show that they acknowledged that. So just a few tips, to make sure that your team is, well informed here.
So we've got just a handful of odds and ends that we'll wrap this up with that we want to make you aware of. First, employees who are transferred to another position or location, it's not within your company. That's not like they can't be treated like a new employee. So they go from one position or one location to another within your company, then everything continues in terms of the time that they have, the timelines that they're on, and their access to the benefits. One kind of asterisk around that is if somebody changes jobs and they go maybe to a different classification where they might go from they were part-time and on an accrual basis, they became full-time, now they're front-loaded. Obviously, there's some changes in their benefits that happen at that point, but merely moving locations or changing jobs within a company doesn't mean that you could treat them like a new employee. Okay, so they're not considered a new employee under this law when you move locations or jobs.
The benefit year is a regular and consecutive 12-month period, and it's determined by the employer. So that could be a calendar year, a fiscal year, an anniversary date. So that would be up to you to determine what works best.
The Earned Sick Time Act, there's, in terms of the increments when somebody uses it, the law calls out 1 hour increments as one of two options. So you can either say that employees can use their earned sick time in 1 hour increments or in increments that are no smaller than the maximum or the minimum required under other types of leave. So that one thing I want to acknowledge on here though, so the law says, let's say right now you have a policy says, somebody takes PTO, then they have to take it at least 4 hours at a time. You can't take it any fewer than 4 hours at a time. Well, under this law, you could pick that as your increment for earned sick time too, where you say, look, if you're going to use earned sick time, it's got to be 4 hours or more at a time. I can tell you though, under discussions with the regulators, that they're thinking of 1 hour as being the largest increment. It's not what the law says. And I disagree with their interpretation, but I want you to be aware that in my discussion with the regulators at the state, they're saying that you can do it 1 hour or the same increments allowed in other PTO in your policies, as long as it's less than an hour. So they're thinking that your increments, if somebody wants to use PTO in 1 hour increments, that no matter what the other thing is, you should let them use that. Maybe someday that'll get litigated. Maybe someday, there'll be a more kind of definitive answer. I think it's pretty clear in the law. It's actually clear in the state's written FAQs and that the regulators published, which essentially just explain what the law says, that whatever increments that you use in other forms of leave, the smallest increment allowed in other forms of leave, you can use for ESTA. I don't think that they're imagining that some employers say that other forms of leave you have to use in 4 or 8 hour increments, that you can't use them 1 hour at a time. And I just want to make you aware. I think that if you use larger than 1 hour increments, you're okay according to the law. But the regulators, I just happen to know from conversations that they're viewing it a little differently than that and considering 1 hour as the maximum increment. So if you do use a different increment, there's some risk in that. I think the law's on your side. The regulators are trying to think of it more narrowly than that.
So the Earned Sick Time Act may run concurrently with FMLA, the Family Medical Leave Act, provided that the leave meets the requirements of FMLA. So this would only apply if your company is subject to the requirements of FMLA. But just know that you may want to include that language in your Earned Sick Time Act policy if your company is subject to FMLA. Which is if you have 50 or more employees.
Documentation is important in this law. While some of the most egregious presumptions against the employer were removed from this law, it's still very clear that if the employer does not have records, you're going to lose in a dispute. So you're going to want to make sure that you document the difference when somebody's asking for time off. And Earned Sick Time Act is an entitlement, not a discretionary benefit. You must provide it. So if somebody's asking for time off or you're granting time off, you really need them to tell you, I'm using earned sick time. So, and you're going to want to document that, keep track of time off that was used for the earned sick time to be able to defend yourself if there's ever a dispute or a claim that you didn't meet the requirements. The other thing I'll say about documentation is that you may only require that a person provide documentation proving the need for their earned sick time if it's more than 3 consecutive days of absence. If a person is gone for 1, 2, or up to 3 days, then they can claim earned sick time, and you may not require them to prove or provide documentation about their absence in what it was for. If they say they want it and they have the time accrued or the time available, and they say it's for an Earned Sick Time Act purpose, you can ask questions, but you cannot require documentation until more than 3 consecutive days. So 4 or more consecutive days of absences. That's the point when you can require documentation. So there's an accountability issue for absences up to 3 days. You can require that they notify you, but you can't require them to provide, for example, a doctor's slip. One other kind of oddity in this law is that the employer must, if you require documentation after 3 consecutive days, and the employee has out-of-pocket expenses because of that, the employer has to pay those out-of-pocket expenses, including things like co-pays or doctor visits.
And then the last thing here, something to consider is to conduct a Fair Labor Standards Act, also known as FLSA analysis of all of the positions in your company. There's an analysis that you can do of their job duties for each job description to make sure that they're appropriately classified according to the Fair Labor Standards Act, meaning should they be classified as an exempt or salaried employee, or based on their job duties, are they a non-exempt or hourly employee? This is a really important time to do this type of exercise because it's really important that they are it ties into their accrual essentially. So for a non-exempt hourly employee, they may be entitled to accrue more hours because they worked overtime. So if you have someone who is classified as exempt, salaried, but then after conducting this analysis, it's like, well, maybe they should be moved to non-exempt hourly. It's really important that you do that to make sure that that accrual is correct. Another thing that we recommend is to review the status of all of your independent contractors. There's a resource out there. It's the Economic Realities Test, and it's a multi-factor test that you walk through all of these different factors to help you determine if an individual should be considered an employee, a W-2 employee, or if they're an independent contractor on a 1099. Because if they are determined based on this test to be a W-2 employee, then they should be offered and entitled earned sick time benefits.
Okay, as we finish up our presentation here and get to some questions that I see that came in, just want to make you aware that we have a comprehensive toolkit. This is real. These are templates, and they're plug and play style templates. You can cut and paste and put in your current sections, or you can just use them as they stand and essentially fill in the decisions. They're marked when you have a decision point. Do you want to choose this method or that method? Do you want to choose this method or that method in different sections? You can really go through plug and play. And there's a lot of items in here. We've got a checklist to make sure that you know what all the things that you need to get to on this. Make sure you don't miss anything. We do have best practices, and we go so far as the headcount calculator. You know, if you're clearly below 10 employees or you're clearly above 10 employees, then like you don't need the headcount calculator. But if you're right on the verge, you might want to utilize that resource just to make sure that you're counting everybody correctly according to what the law requires. We got all the templates and the different types of leave for 1 to 10 employees or more than 10. If you want to combine your leave, you want to keep them separate, we got templates for each of those things. But we also, the Earned Sick Time Act has a lot of purposes, a lot of things that an employee could claim Earned Sick Time Act privileges for, way beyond just being sick. I wish they didn't even put the word sick in the act, because they can use earned sick time for many, many more things. And it's not just for them, it's for their family or anybody that is like family to them. And you, as the employer, you don't get to decide that. This makes it clear in the ESTA covered purposes template. And then we go so far as to have templates for absences and tardiness notification policies that are compliant with the Earned Sick Time Act and definitions. And even on if you have a part-time worker that you're front-loading benefits for, how you do the estimation of hours that you provide prorated to meet the requirements of the law. So all those are available to members that are VIP or elite status. I wanted to, on the next slide here, just share that if you're not a member yet, or if you are a member at a lower level. Here are the prices for the whole toolkit that come with it. It's not really listed on that previous page, but also we're here for you as well. So you're going through and you got a question, hey, I'm on your template, I don't understand this, or let me lay out a scenario and what do you think? These are things that Scout and I do when folks are using our templates. By the way, we would rather just have you as a member than to just buy the toolkit from us. That way, when we're doing these sorts of things, you're part of the family in the first place. And we have this service, it's called Ask an Expert. And let's say later on in the future, you've got an HR problem, you've got a legal question, you've got an accounting question, and you just don't have like a pro at the ready to talk through or to submit those questions to. We have a system for that, and it's a good benefit, plus all the other stuff that we do. So would rather have you, the math works out, so it's more advantageous to just join and be a part of it. And so you get the toolkit and everything else that comes along with being a member of SBAM. All right, Sarah, you've been keeping track of questions. Let's go ahead and get to those.
All right, all right. So the first person asks, what if our handbook says benefits such as healthcare? Can we change the handbook to say ESTA benefits start at 120 days?
Yeah, so you can combine it with other existing, certainly if you have like sick time or healthcare type benefits. Doing this instead of that or in place of that would be would be pretty logical and appropriate to do. The and even if you want to combine it and say, look, we're going to do 80 hours of paid time off and it's available for earned sick time, but if somebody wants to use it for vacation, that's fine too. It's at their choice. It was available for earned sick time, but they used it for vacation instead. So yeah, in that scenario, you can do it, but you can go even further. You could actually combine it in with a general leave policy that covers everything, including vacation. But certainly for healthcare related leave, you could count the Earned Sick Time Act and do that instead of a separate sick leave or a separate healthcare leave.
So if an employee has requested time off for, say, a wedding, and then they provide a doctor's note after the fact for the same day they were off for the wedding, is the employer required to pay the employee for ESTA hours accrued that day?
Yeah, well, here's the tricky part. So as the employer, you are not allowed to require documentation until the third consecutive day of absence. And so accountability for when somebody claims earned sick time and it's less than 3 days, accountability is really tough in this situation. Now, people living very public lives and posting everything on social media, it does create an interesting opportunity for employers to call people out for inconsistencies like this. The state's FAQs definitely allow you to ask questions to an employee regarding their claim of the need for the Earned Sick Time Act. So somebody's saying one thing and doing another. If you have proof of that, well, that's a violation of the law. Going to a wedding is not an act protected under the Earned Sick Time Act. Now, a doctor providing a note after the fact, I mean, I don't know if there's some kind of professional board that you could report that to, and that this person was obviously not sick because look, there's a video of them dancing at the wedding or whatever like that. There's not just a clear black and white answer to this. As the employer, you're literally not allowed to require documentation. They say, I want to use Earned Sick Time Act. You just have to give it to them. And but in this case, since they did provide documentation, but it was in conflict with something else that you know in some other way, if you have proof that a person was not truthful, the law doesn't protect them for that. So what I would say is tread carefully. If you do have proof and the person violated your policies and is not protected under this law, they use the time for something not protected under the law, then you'd be in pretty good shape, I think, to deny it. But is it possible? Here's my kind of red flag when I put my, it's not exactly a conspiracy theory hat, but I always like to imagine the worst case scenario. Is it possible that a person qualified for the Earned Sick Time Act and also went to a wedding? Yes, that is possible. Somebody could be sick and also go to a wedding. That's rude to get people sick at a wedding, but it could happen. And so that's where I think for me, as think about an employee of dozens of employees here at our association, these are the sorts of things where pick your battles kind of comes in. But I imagine that if somebody said, yeah, I'm using earned sick time, and then I see on Facebook that they were, at the beach hanging out with their buds, they might say, well, that was a mental health day or something. I don't know. I mean, these are things, it's a pick your battles type of a thing, but the Earned Sick Time Act does not protect the ability of an employee to be absent for a wedding. But could they be absent for a wedding and also qualify to the Earned Sick Time Act because they're sick, or family member is sick, or they had to transport a family member who was sick to an appointment, or that a child with a disability that had a meeting at the school that same day? Yeah, it's possible that both of those things could be true. So I would say be careful, but if you could prove it, that they did not have a qualifying event, then they're not entitled to earn sick time. Long answer, but it's a pretty complex question.
It is definitely complex. All right, this person asks, if we front load salaried employees, but then they have a new salaried employee join the team partway through the year, can that employee accrue hours until the next calendar year so they don't have to front load the whole 72 hours when they are only working a half year?
Great question. And the answer is yes, but I want to give you a couple of options in this scenario. So you got a salaried employee, they're starting, but they didn't happen to start on January 1st and you're using your calendar year. Yes, you can say for the remainder of the calendar year that you start, you are on accrual basis. And then when you flip over to the next year, you go to front loaded. As long as all new hires come in under those circumstances, you're treating all similarly situated employees equally, you can absolutely do that during your first partial year accrual. After that, front loaded. One thing you could also do is you could say, well, instead of 72 hours, this person is starting on July 1st, and that is 50% of the way through the year. Therefore, we're going to front load 36 hours instead of 72. You can also do it that way. You can prorate it based on how much of the year is left, and not, if you don't want to mess around with accrual, stick with front loading, just prorate the year. You want to do it by number of days, not by number of months. Okay, so in terms of your proration to make sure that you get it exact, but ultimately those options are okay. So the way the question was posed, yes, you can do it that way, and I just want to give you the proration option as well.
All right, this next question is about calculating the number of employees. So they ask, if I employed 14 employees over the full year, but only had 15 weeks where there were 11 or more employees who worked a given week, are we considered 10 or less because we were under the 20 weeks?
Yes, under the facts as laid out in that question, you're considered 10 or less until you have 11 or more employees on 20 consecutive weeks during the year. By the way, those weeks do not have to be consecutive. I'm sorry. So as long as you are, is the, and I may have, let me start that over, so I want to make sure I didn't say that incorrectly. If you have 20, or if you have 11 or more employees for 20 weeks or more, even if those weeks are not consecutive during a particular year, you count as a larger employer. If that is anywhere 19 weeks, 18 weeks, in your example, 15 weeks, then you still count as a small employer. So you'd have to meet the 40-hour week, not the 72-hour week.
All right, next question. Is it permissible to use employee work anniversary on the poster rather than calendar or fiscal year?
You can use the anniversary date of the employee as that year. You are permitted to do it that way. So calendar year, or fiscal year, or employee anniversary to recharge or reset the benefits each year. All of those are permissible under this law, as long as you're consistent with it. So regular and consecutive 12-month increments, regardless of which ones you choose, which way you choose, are allowed under this law.
All right, this next person says we have a bundled policy, ESTA, within our PTO. If an employee has an ESTA qualifying event and has enough PTO accrued, but does not have enough ESTA time accrued, do we record this time as ESTA because it qualifies and only reduce the ESTA accrual by the amount they have already accrued? Or do we only claim ESTA hours that are actually accrued and use PTO for the balance?
So in your policy, let me talk about what the law requires with respect to that question. So you only have to grant, you're only obligated to grant time off with pay up to the amount that's accrued. Anything beyond that, if you want to pay it, it is at your discretion according to your policies. So if the employee has time off for ESTA, but they don't have enough ESTA time accrued, and they have other PTO approved or accrued or other PTO available to them, you as the employer, according to your handbook, if they're entitled to use it, then you let them use that. But that's at your discretion. Then there's no entitlement of the employee to any paid time off that is not accrued under ESTA. Once they exhaust that, then it's the employer's discretionary paid time off, and whatever policies you have around that are the rules that you follow, and those are not dictated by the law. So in this case, like just because somebody has an ESTA qualifying event doesn't mean that they get paid time off for that whole event. They only are entitled under the law to paid time off for the amount of ESTA time accrued. Now, if you do have combined leave banks, this can get complicated, because under a combined leave bank, let's say you give 120 hours, but ESTA only guarantees 72 under the law. Well, 72 hours under the law, that's all they're required to provide. And that can get pretty messy as an employer, what under that circumstance. So actually the way we handle it here at SBAM is we have a combined leave bank here of a policy that's kind of unique at SBAM, but we have a combined leave bank that that we really don't when somebody uses earned sick time up to 72 hours, we don't cut it off there. Earned sick time. If there's other time available, they just use that other time. They're not guaranteed that under the law. So you have some room in there to establish your own policies beyond what is guaranteed by the Earned Sick Time Act. So if that wasn't clear, just indicate again, and I'll try to answer it again.
All right, the next question asks to please explain how the 1 hour increment works for salaried employees.
So with a salaried employee, let's say they're gone for an hour, and it's for an Earned Sick Time Act qualifying event. They had an appointment one morning, they got to work an hour late. Now, you as the employer, if you would normally dock their pay for, like, even if you're salaried, you can still say to somebody that you can just keep track of the hours and say, well, you didn't work enough hours and therefore we're going to dock your pay for the time that you missed. You could do it 1/40th of the weekly paycheck, or you could do it, if they're gone for the whole day, 20% of the weekly uh, amount. So that proration can be done in any circumstances. But if a lot of times a salaried employee is gone for an hour or less, there's not, an employer is usually not going to dock the pay for that. It wouldn't be like a normal practice to do that with most. So in those cases, an employee might not even be in a position where they have to use earned sick time. Um, just decide whether or not, do you want them to submit and use time? But if it's an earned sick time, you can't dock their pay if it's an earned sick time qualifying event. And so it's just a smaller increment. It's the same as if they took a vacation day or something, or took a partial day vacation. If it was 4 hours or 1 hour, it's just a fraction of the total. So if you want to think of it in simpler terms, just take the regular amount they would make per week. If their standard work week is 40 hours divided by 40, that's the equivalent hourly basis that you would be making up through the Earned Sick Time Act. But if you have the type of culture at your company where absences or tardies that are that small, and they say, I'm just be a little bit late into work today, and they just get their salaried paycheck and you don't do anything about it, well, you're covered. The Earned Sick Time Act is just when you would otherwise not pay them. If that's not the sort of thing that you would reduce their pay for, they're just late one day and they just get the full paycheck and it's the same paycheck because they're salaried. I don't really think you need to worry about that. There's you're not going to be reducing that Earned Sick Time Act pool, but that's okay because if you're not carrying over, it's not carrying over to the next year anyway. If they're front loaded, and even if they're on an accrued basis, there's a limit on how much they would be carried over. So I think a lot of companies in that scenario that you just laid out, like they're only going to be gone for an hour. Are we really going to kind of monkey around with all this? As long as you pay them the full amount, you're going to be good.
What if you have an employee who never asks for ESTA time, but just takes their time off as regular paid time off?
I was pretty thankful that the regulators addressed this so explicitly and clearly in their FAQs. And if you have a combined leave bank and you say this can be used for ESTA purposes or for discretionary purposes like vacation, if the employee decides to use it all for a vacation, they use it all for a vacation. It is no longer available for ESTA. They can't say, oh, I took a vacation, I used up all my time, but now I need it for the Earned Sick Time Act purpose. Well, too bad. You already used it for a different purpose. The law is very clear on this, and the state's regulators in their FAQs were very clear on this, that the employee cannot change their mind after the fact and say, I wish I wouldn't have used it for vacation. Once they burn it, they burned it. And you're not under any obligation to make up for the fact that they used their time for vacation instead of sick time.
Is there any reason to believe that there will be changes to ESTA before this next deadline in October?
There is, I would say, close to a 0.0% chance of changes. So no, I don't think there's always, people talking about different things, but I think that the chances of change on this are so small that I would just assume this is how it's going to be. In future years, we haven't given up on making changes to it, but in future years at SBAM, we don't really like these kinds of laws. We advocate for fewer controls and mandates on businesses, especially as it pertains to employment practices. But this one just went into effect. It was a major lift to have changes made in February. for the system and for the legislative system. And I don't think there's any realistic chance of changes happening before this goes into effect.
So earlier we talked a little bit about prorating and front loading for salaried employees, but can you do the same for hourly employees? If you do use the front load system, can you prorate their hours? Maybe
So for a salaried or for hourly employees, if you're front loading, what you do is you estimate based on their expected work how much they are entitled to receive. If you do your proration, or if you go through and do your proration, if the amount that you're giving them is less than 72 hours, if you're 11 or more employees, or less than 40 hours if you're 10 or fewer employees. If you're not reaching the max requirement, anything less than the max, then at the end of the year, you must look at actual hours worked and do the math and determine whether or not you awarded the correct amount in the beginning according to what they worked. So if you front load the full amount, the full 72 hours, you don't need to track or true it up at the end of the year. You know you're good because you gave the max. If you front load something less because you expect them to work fewer hours than what would get them to the max, then in that case, you do need to track their hours and determine, did you give the correct amount at the end of the year? So hopefully that's clear. There's not a definition in this law of what's part-time and what's full-time. Basically, it's just a matter of if you give the full 72 hours or 40 hours, depending on your size, then you don't have to track. If you give anything less than 72 or 40 hours, depending on size, then you do have to track, because that's really kind of a de facto definition of part-time.
another question about front loading. So this person says, how would it work if you are front loading for your full-time employees and using accrual for part-time employees? And then you have a full-time employee who wants to go part-time after already receiving and using some of their ESTA time off.
Yeah, I mean, once the time is used, it's used, and it doesn't, you can't count that against or get that back from employees because it's their employment status changed. So they were in one category, say they were full-time and they got the full 72 hours and they used all 72 hours. And then later on, they decided they went part-time and you approved them going part-time. The conditions of the employment changed. They've essentially started a new job within the company. They'll now fall under whatever your company's policies are for the part-time employees, but you can't go and get back what they used when they qualified for it under the full-time status. So in that case, it's just a matter of a sunk cost, if you will. They had the benefit, they had 72 hours, maybe they used the whole 72 hours, they switched to part-time, and then at that point, they get whatever they get as a part-time employee under your handbook, but you can't get back, and you can't kind of essentially put them in a deficit position in the new one to make up for what you lost in the full-time employment. So it really is kind of a sunk cost situation.
This is kind of a follow-up question, more of like a speculation, but why would an employee specify if they are using time for ESTA reasons in case of front loading more than required if they use it all anyway?
Yeah, I think that's a fair question, but if the interest of the employee to claim the Earned Sick Time Act is because at that point it is an entitlement that you, the employer, must give them. You may not deny. So essentially, when they use Earned Sick Time for a qualified purpose under the Earned Sick Time, they are not seeking approval of the time off from you. They are notifying you that they're taking it, and you are compelled by the law to approve it. If they do not claim Earned Sick Time and they just want paid time off, then under that scenario, you, the employer, can decide, no, it's not a good time. I'm not going to let you take time off right now. You can deny it unless they're using and claiming Earned Sick Time. So it's just a matter of the employee's in the driver's seat if it's an earned sick time. The employer is in the driver's seat if it's not earned sick time.
Okay, one final question. If your healthcare, if you offer the healthcare, but sorry, I'm reading off my other screen. If you offer the other healthcare benefit at 60 days, can you have ESTA start at 120 days, or do all benefits have to start at the same time?
Well, I don't know that I understand the question, but if it's a matter of whether
Think for a
the
new
meeting,
hire. So I'm new, and after 60 days of employment, my healthcare benefits kick in. Can you have the ESTA benefits kick in after 120 days of employment, or would I have to have those two things in alignment as a new hire?
oh, no, you don't. I mean, the Earned Sick Time Act can be an island. It can be something that operates independent of every other benefit. So if you have accrued benefits and there's a 120-day waiting period, even if you have a different benefit for healthcare that starts at 60, you can do that. Sounds pretty complex. You might want to think about doing away with the healthcare one and just doing the Earned Sick Time Act. That would kick in at 120, but the Earned Sick Time Act does not have to be stacked on anything else and doesn't have to be coordinated with anything else. It's a requirement, and you can meet that requirement, and the other things that you're doing are discretionary. In terms of paid time off under Michigan law, the other things that you do are discretionary. You can decide if you want them to be stacked or concurrent or a gap in between, those sorts of things. As long as you're meeting the requirements of the Earned Sick Time Act, those other things can be modeled at your discretion.
All right, those were all the questions that we had, but I did just drop in the chat our email address if something comes up. You think about it a little bit later, today or tomorrow, you can email us at sbam@sbam.org.
Thanks for joining us. See, good luck, and happy to walk alongside you as we move forward from here. Have a great day.